Let's get into some of what Julie laid out there. First and foremost, right, the argument that is being made by Mark Meadows, former chief of staff to Donald Trump, and his attorneys as well, for full dismissal when it comes to the charges leveled against him in Fulton County. And the argument being made is based upon this. And I want to read it for you. A federal official carrying out his duties is not, quote unquote, obliged to consider state criminal law at all before acting. What do you make of this argument, and does it have any traction?
No, Yasmin, I don't believe it has any traction. And importantly here, it's premature. This motion was filed in federal court in front of Judge Steve Jones, who can't even rule on it until he makes the determination as to removal or remand, because he doesn't have jurisdiction, if that makes some sort of sense. Until he decides that question, whether the case will be a federal case or he's going to remand the case back to the Superior Court judge, then none of these other issues can even be addressed by the judge. So that's a procedural matter. But secondly, I'll say this. I think it sounds a lot like some of the arguments in his motion, in Mark Meadows' motion to remand, and a lot of things you hear from Donald Trump, which is focused on who I am, not what I did. And, you know, frankly, that's got a very authoritarian ring to it. But you see that as an excuse a lot, you know, that I can do whatever I want because I was chief of staff. I can do whatever I want because I was the president of the United States. And that simply is not the law.
I'm glad you brought up the possible movement to federal court, or at least the ask from both Mark Meadows and Giuliani for it to move to federal court. I believe the hearing for Meadows for that is August 28th. What is your expectation on that movement?
Well, Judge Jones, who's got the case, is a very experienced trial judge, been a trial judge since the 90s, and been on the federal bench for a number of years. He is fair and courteous to litigants. He's going to hear the arguments, but he's not going to waste time. And that's why he's already set this hearing for August 28th. He'll hear the arguments. He'll hear the arguments of the state, and then he'll rule. It's not as simple as some are saying, that because you are a federal official, then state prosecutors cannot prosecute you. If that was the law, this would be a quick motion. That's not the law. It has to hook into your duties and responsibilities as a federal official. And that's where I believe this motion is going to fail.
You worked, actually, Charlie, with Fani Willis when she was lead prosecutor on a 2014 Atlanta Public Schools cheating scandal. In that case, 11 black educators, they were convicted of racketeering and conspiracy for allegedly cheating or enabling cheating on student standardized tests. Based on your experience with the racketeering charge in the state of Georgia, how strong of a case do you think Fani Willis has here?
It's a very strong case. You know, the statute, the RICO statute was written here in the state, not exactly mirroring the federal statute, but fairly close, to catch up to defendants that were trying to disperse their conduct as a way to avoid accountability. So what you have here in Fani Willis and her team, what they've done with this indictment is telling the entire story. So there's nowhere to hide. And so that a jury eventually, when this gets to a trial, has a full understanding of the context that all these actions were taken in. And so it's a strong case. Now, every case is only as strong as the evidence at trial. And an indictment, of course, they're allegations. But once we get to trial and we see, I'll tell you this about Fani Willis, she doesn't put a charge down unless she's got the evidence to back it up. So I think it tells a strong story about the attempt to overthrow our election here in Georgia. And I wouldn't want to be one of the defendants in this case, I'll tell you that.
Charlie Bailey, thank you, sir. Appreciate it.